that that would be the case. Because we're going to assign roles for Thursday's class, that's why. So remind me when we get to golf, we'll do that. But just to recap, we're going to start with Yoder today. And again, I've drawn on the board cases that stand for parental rights, children's rights, states' rights. So we've already done Meyer and Pierce.
And Prince.
Right? And what did you read?
Prince.
And Prince. So again, where am I putting Meyer and Pierce?
Under parents.
And Meyer stood for what? The parental right to do what? You have to put it in one sentence, John.
To teach, to decide how to educate their children.
A little broad though, right? Make it narrow as to Meyer. Yes, in the end, that was the wellspring for that proposition. But it was the parental right and teacher's right to do what? Be instructed in German language, right? And then Pierce stood for what? Lester?
I'm sorry, Professor.
And Pierce stood for what? The parental right to...
I have to look at my notes.
Easy.
Well, okay.
Because it was the compulsory school attendance law that was before the court that the parents ought to be exempted from because their children were going where?
Private schools.
To private schools. I'll just say to go to private school, etc. And Prince, Jadita, you said Prince falls under states' rights. Want to put that in a clause or a sentence?
I'm trying to remember what the case
child labor.
Yeah.
Oh, yes, okay.
Patricia, you want to help or is Jadita?
No, go ahead.
You have. We talked about the state's right to prevent children from
Go ahead, you got it.
to prevent children from working at a young age.
Actually, to prevent parents from doing something, right? Remember, the Pierce child is not the mere creature of the state, right? The parents have the right, liberty under the 14th Amendment to bring up the children the way that they please. And while the Sarah Prince had not only the 14th Amendment liberty right that parents have in Meyer and Pierce, but also had the First Amendment right to practice her religion along with her child. But even so, she was not able to succeed, right? And the reason why was that the state has the right to do what, Jeremiah?
Regulate labor.
To regulate labor because of what?
Age.
Huh?
Age.
And school?
Right, but what is the interest in children that the state has? So up here, the parental rights is, leave us alone, leave the family alone. State should not interfere with family rights. State has the right to interfere when what?
It's for the welfare of the child.
Yes, to prevent parents.
Violation of child labor laws?
Endangering the welfare of the child.
Absolutely. Child labor, endangering child welfare. Beautiful. Okay. So now we're at Wisconsin v. Yoder. Somebody volunteer for that last time?
I did, then I ended up doing another case.
Oh, all right.
But I can continue to grab that.
If anybody else wants to volunteer, that's
Are we still in this section that we were at the state?
Yes, yes. So Patricia, you want to represent Wisconsin? Did you already volunteer?
I did.
You didn't? Huh?
I did.
You did.
Mhm.
John, did you?
I did the first one.
Okay, so Jeremiah, you got it. Wisconsin. And then I need somebody for the Yoders.
I'll do the.
I'd like
others
to
if
do
you
it
want to go
next.
out.
You want to do the next case? Talk some. Okay.
If you want to go outside, I'll do the Yoders.
Richard, have you?
Yes.
You're on me. Joe. Okay.
Yes.
So Joe represents the Yoders.
Yes.
That's my case. Okay. Jeremiah, you want to go first?
Okay,
Representing the
so-
state of Wisconsin.
Yeah, state of Wisconsin has a law making it compulsory for all students to attend public schools until the age of 16.
Okay.
And the Amish do not abide by that. They endorse the elementary education, so they
Mhm.
agree with the law to a point. But they, for religious reasons, said that they were not going to send their children to high school, mainly because they said that the public high school environment was going to expose them to ideals and situations, whatever you want to call it, values that are not in accordance with the Amish belief and would.
So what did the
harm.
state, just to get the procedure down, what did the state do originally?
Oh, they,
When,
they
with the
pro-
knowledge that the Amish were
They filed charges.
violating?
They filed charges against several Amish families.
Okay.
And the courts ended up convicting the Amish families of violating this, I don't remember the name of the law, but failure to send your kid to school till he's 16
Okay.
law.
That's called the compulsory attendance law.
Yeah.
Okay.
And then the Amish appealed and declared it unconstitutional in the sense that it interferes with their religious freedom.
What did the Supreme Court of Wisconsin hold? Because you're appealing from that as the state, correct?
Oh, they went with the Amish on that one.
Okay.
On appeal, right?
Yeah. So, yeah, the state had one with the lower court. I think, did it go through all three?
And
levels?
that's why you're here, as the state.
Yeah,
Petition in the Supreme Court, correct?
right.
Okay, all right. So what's your argument?
State's argument?
Yes.
Well, the state's argument is, the state has the power to enact or impose reasonable regulations having to do with basic education. Now, precedent, the state did acknowledge that there's precedent out there that says that parents have the right to provide equivalent education in a privately operated system. But the state has the power to do balancing tests, whatnot, but for the Amish to just flat out say, no, not provide an equivalent, the state's argument is that some degree of education is necessary to prepare citizens to participate effectively and intelligently in the political system, and education prepares individuals to be self-reliant, self-sufficient participants in society.
How would you use the Prince case to argue on behalf of the state that the Supreme Court should know?
Well, I mean, you could tie
Probably
it in.
following the reasoning and the holding of.
You could tie it into welfare. If the kids aren't in school, what are they doing? You could argue, just like with Prince, as the state could argue that it's in the children's best interest. I guess, not to be too dramatic, but they could say it endangers the child's welfare to not be in school.
So what specifically is the state's interest in having children in school past the 8th grade? I mean, haven't they by then learned the basics? What else do they need to learn that would be clearly the responsibility and the duty of the state?
I think that was what I
And
kinda-
any of the state, when I asked the
The higher
questions,
level
any of the state
academics?
people could answer as well?
The higher level academics, I mean, by the 8th grade, they do have the basics in
Right.
math, writing, speaking, communication, as well as English, because the Amish are brought up with, until they go to school, with the Pennsylvania Dutch, but It would be higher level, and to keep them out of trouble, keep them out of work.
Okay. Can I ask either either children or, before I hear your argument, Joe, either the children or the parental advocates, there were experts that testified for the Yoders. Anybody want to summarize the expert testimony below? What did the experts say?
On behalf of the Amish people,
Right, Richard?
that the extra 2 years of school would not benefit the children as much as they could possibly be harmed by.
What? Why? What's the peculiar nature of the Amish tradition, say, versus the Jehovah that we just encountered in Prince?
The family structure in the Amish culture is so geared towards their religious beliefs that
But doesn't every religion profess that?
I don't think so. The Amish were so strong in their beliefs and their culture that it was detrimental to put them into public schools because they were learning certain values that were totally foreign and against the Amish culture and religion that they were learning at home. And the experts said that those 2 years of education weren't going to benefit the children as much as it was going to hurt the children not being in their culture and community for those years.
How would you just describe more as to the Amish way of life? Joe?
Well, first of all, the Amish way of life in general is a religious-based organization. And they're specifically devoted to the soil and the land and living off of the land. And they're taught ultimately from a very young age to accept those values in their life. And so, whereas the importance of the actual traditional school values are certainly important, and it's important that they learn how to read and write, their values, their core values are ultimately different, and they specifically relate to learning about environment, learning about sharecropping, learning about how to raise and create barns and actually literally make certain cuts in wood to be able to make sure that the structures are freestanding. So these things they would not learn in a traditional school. So ultimately, it actually destroys them. It takes them out of a set religious-based environment where they learn core values off of the land, and it puts them in a traditional environment, which when they go back home to the Amish community is completely adverse to their specific way of life.
So how would you, the state made an argument, using Prince as the leading case. How would you distinguish Prince as an advocate for the families here, the parents?
Well, I would suggest that in this case, it differs from Prince in that this is specifically related, this argument is specifically related to the Amish way of life. And the Amish way of life is different in terms of how they go about doing things. And so, for example,
isn't a way of life different from freedom of religion, a First Amendment argument? Shouldn't the reasonable regulations of the state regarding education take more importance than a way of life?
I think in this case, I believe the Amish way of life is set in stone, in that these are the ingrained values that they learn. They're religious based, but they specifically involve living off of the earth and actually being able to support themselves. I don't know if you've ever been to an Amish community, but I have. I have.
Wow. Oh, okay. Well, we'll hear from more of you then.
I mean, you're talking about, here we are talking about this case. In fact, the Amish way, I mean, they ride in horse and buggies around,
right.
And they have to dress a certain way, and they have to actually perform physical duties. Everybody in their community has a specific job, and it has to be done, or the order doesn't work within the community. So this law in this case is specifically related to it affects the Amish. I mean, it's what we're talking about. We're not talking about other religions. We're talking about the Amish religion in general.
Who else just had their hand up?
I think one of the most important things is in the Amish culture, at the age of 16, they give them the choice of whether they want to continue in the Amish religion and culture or they want to spread out. if they stay in court for those extra, I mean, if they stay in school for those extra 2 years, they're going to be influenced at the exact point where they have to make that decision. And I think the Amish's argument was that if you keep them and they learn those values at 15 and 16, they very well could come back and say, I don't want to be involved in the religion. It could lead to the absolute destruction of the religion if all people of that age suddenly started learning those values and turned around and said, I don't want to continue in my faith. It could literally destroy their faith.
Who else wants to give us information about the Amish?
Oh, another thing they spoke about in the case, they said that the Amish, they don't teach competitiveness. They teach them to be one, and they teach them that the earth that God gave them, they are responsible for taking care of this earth. So they feel that in the high school where they're learning sciences and math, and they're learning to be competitive, and you have to be the top of your class for college and so on, where in their community at that age, that's where they have to start learning to be responsible as, Amish, as taking care of their land and so on and so forth. So that's another argument that they brought up.
Tim, you said you had information.
Oh no, I was going to say how it differs from Prince in the fact that they're discussing that if they're forced to go to public school, it could actually destroy their religious beliefs, versus Prince, where they're just stopping them from working under the age. It's not really affecting their religion in any way.
Patricia?
The case really relates a little bit more to Pierce, because the Amish go to Amish school till they're from kindergarten to 8th grade. So they have their own private schools that are taught by their Amish girls that are usually 16 to 18 till they get married. So they're really kind of off the grid in terms of that. What I think Joe said about, what did you just make a statement about? Oh, that they're asked, most of the time they're really not asked, although they don't do science. It's against their religion to teach science at all. So they don't want any innovations because they don't have them in their homes. The most they have is kerosene for making pumps and things work.
Ash?
And it's not that the Amish people object to education, because they want them to go to elementary school and learn their basic reading and writing skills, so they can read the Bible, and also for them to expose themselves to people that are not Amish, so they know how to interact with them when they need to go to the city to get something. So it's not that, like Tim was saying, it's contrary to their religious beliefs if you're going to force them to go to a higher education to teach them competitiveness and scientific innovation.
So if we're looking at Yoder now as either a children's or parental rights case, etc., in the nature of, for example, Pierce dealt with the compulsory education law as well. So if we look at Yoder as an exception to the compulsory education law, what other exceptions can you think of besides, I don't have to send my kids to public school, I can send them to private school. If you're Amish, I can send my kid to school through the 8th grade, but after that I don't have to, so I'm exempted from the compulsory education statutes. What other exceptions can you guys think of that has occurred since then?
Like homeschooling?
Yeah, right? Still subject to a lot of state regulation, but homeschooling is certainly an exception as well. So, what about the children? But anyway, we're going to put Yoder on the parental rights. The right of the Amish, right? To keep children out of public school after the 8th grade, right? And it's their 14th Amendment substantive due process liberty right plus their First Amendment right. That is the basis for their constitutional right to have the state not tell them what to do with that. So what about the case can be sort of introduction for us in terms of this that children should have voices too. Children should have a right to present their views. John?
Well, I thought this was an interesting case because I didn't think they quite dealt with the problem head on, and they might have been sort of guilty of giving the Amish special treatment that wasn't really ultimately going to be helpful. So in the case, a lot of times they talk about the special problem of adolescence, or they talk about how adolescence is a special problem, but they never define what that special problem is. And they only talk about, and of course, Douglas's dissent talks about how the children really have.
That's what I'm getting to, right?
So I think
The
really
dissent.
they have a problem, which is that adolescence, the age when you start to think that you can't really make decisions like an adult, that you start to see that adults don't have all the answers. And I know that the Amish community has a slight problem with this, because I know they do things for young people. They allow them like to go out and see music and maybe drink soft drinks or whatever. But the court never really deals with that problem.
I don't think it would have changed. I mean, I read the dissent.
Jeremiah? I'm sorry.
I don't think it would have, the outcome would have been changed, but he's right. It seemed like they kind of skirted around the issue, which was, yeah, what's in the best interest of the kids? But weighed against that is what they did talk about, which
What is Douglas's contention in the dissenting?
that this was all parents versus state. Where's the kids?
Where's the kids?
What's in their best interest, not what's in the parents' best interest. But even if you go that route, like you could, if it did go back, which it didn't, and then you had the arguments for the kids, the other side of that is still the parents' rights to raise their kids in whatever religion they want to, assuming it's not legal, until the kids are 18.
So go ahead.
So I don't think it would have changed, but it's, if you think about it, if the kids had won and they were forced to go to school, it would have eroded the parents' religious, or the parents' right to raise their kids in accordance with their religion.
In what procedural context, children's activists here, in what procedural context would the Supreme Court, should the Supreme Court, according to Douglas, have recognized the rights of the children? In what procedural context? Did the procedural context of the case raise? So it began, as Jeremiah mentioned, with the parents being criminally prosecuted, right? Then the parents brought a motion to dismiss.
There's no due
You're
process.
nodding,
There's no due
Lester.
process for the kids.
Well, just that, your question about the procedural element vis-a-vis the children would be to have them testify, I would think.
Well,
as
what
to-
the majority opinion is saying, we can't say anything about the children in this case because they were not parties. It wasn't part of the question on appeal.
There's no due
Because the
process.
motion to dismiss raised, the parental argument, not the children's argument. But what does Douglas say about that?
That the children should be heard.
Why? Again, procedurally, I guess what I'm asking is, can the children be heard out of this case?
No.
Ash says no. Why not?
Well, because they're not a party of the case. They're not the ones that are being.
So here's a question for you.
Yep.
The parents in Meyer were not parties to the case. Yet, doesn't the Supreme Court talk about parental right, not only the instructor's right to teach the German language, but the parents' right, substantive due process right, to have their children taught in the German language, even though it was the teacher that was criminally prosecuted, right? You all following me?
Yeah. So what you're saying?
I'm just arguing,
Procedurally,
what's his name, Douglas's argument here.
Procedurally, it was because the question wasn't raised. What happens?
That's what the majority is
Yeah,
saying,
what
right?
happens to the kids' constitutional rights if they want to continue education and their parents say no? I think that's what Douglas was getting at. Because that question wasn't raised.
Yeah, notice that, who concurs, Stewart or Brennan bring up part of the testimony. Only one of the children testified, and here's the question and answer, and it's Frida, I forgot what her last name was. So the question is, so I take it then, Frida, the only reason you are not going to school and did not go to school since last September is because of your religion? She answers yes. That is the only reason. She answers yes. But Douglas, what does Douglas say? Well, she testified, but what about the other kids? Or maybe, I can't remember if Douglas says that, or White or Brennan or Stewart who concurred. Because the court never heard from those other children as well. So if anything, we're putting, I guess Yoder dissent under children's rights. Because Douglas says children have the right to be heard, right? The dissent also mentions some cases that you haven't had yet. Mentions Galt in support, which we're going to read next, procedural due process. Mentions Winship, which is a delinquency case that we deal with much later on that has to do with procedural due process rights of children faced with crimes. Tinker, which you will be reading on freedom of expression, and Halley, which was a really old case where a 15-year-old, and in fact it wasn't a delinquency case, it was an adult case, but a child who was prosecuted and held for an inordinate amount of time will ultimately confess. So notice that those are the cases that Douglas relies on to argue that the children should be heard, whereas the cases, obviously, that the majority relies on are the previous cases of Meyer and Pierce. And Meyer and Pierce are the substantive, if you're going to be arguing for the substantive due process rights of families, of parents, Meyer and Pierce are pretty much it. Yoder comes into play, obviously, when a parent also is articulating, arguing freedom of religion as well. Anybody want to say anything else about Yoder? Because I'm ready to move on. We're moving right along today. Lester?
I was disappointed in the Yoder court. I mean, it was an 8-1 decision, and it's 1972.
Which the 70s were the constitutional rights of the child era. And that's why I included the concurring opinions and dissenting opinions in there with you guys. You were disappointed, you're saying, because the majority didn't want to recognize the rights of children, saying, oh, it's not for us today.
It's
Is that what you're saying?
1972,
Yeah.
and the court is saying an Amish child cannot be an astronaut.
Mm-hmm. Right.
And that was the
Right.
era, I mean, it was 3 years prior to
because the Amish parents have the right to say the opposite.
Make that determination.
Mm-hmm.
And here I am, a little Amish boy, I want to be an astronaut.
Oh.
No, they don't know too much about that stuff.
Instead, I gotta walk behind a mule.
Oh, I know, there was something else I wanted, because I remember when we left the other day and I said, compare the language the court uses in Yoder when the court, summarizes the Amish tradition versus the language that the court used in Prince. Anybody want to talk about that? Yeah.
Well, in Prince, they described the Jehovah's Witnesses as having like fanatical beliefs, and where in Yoder they called it a way of life. So it made it seem as if like the Jehovah's Witnesses, they're just doing things off a whim. It's not really something that is part of who they are.
Right.
And they gave the Amish a bigger pedestal, saying that that's what they do, that's who they are. It defines them.
Yeah. Remember the famous quote out of Prince: "Parents are free to be martyrs themselves, but when it comes to the welfare of children, the state has the right to intervene. Yet you have none of that type of language when the court summarizes the Amish tradition. Did you want to say something, Joe?
No, I was just going to reiterate the same point, is to say that they almost give that religion, the Amish religion, more standing. They almost say that it's acceptable.
Not almost, they do.
Yeah,
right?
It's acceptable as the Jehovah's Witness is not.
Mm-hmm. What other tradition can you think of, religious traditions that have been respected, recognized by court systems?
The Shakers.
What's that?
The Quakers and Shakers.
The Quakers. Who else?
Jews?
Yeah. I was thinking of the Christian Scientists. Very
Scientology.
Christian Scientists, not Scientology. Very, powerful in terms of also lobbying the states. They have what they call practitioners, right? We have, and I don't know if we still do. I have to check the statute. We have had an exemption in Massachusetts, and we'll talk about that later on. Actually, with the Twitchell case, I think I've got that in the CD, unless I took it out. That they can treat their children who are ill, or adults as well, with prayer, and parents cannot be subjected to for example, a neglect and abuse proceeding for treating their children that way. The problem with the Twitchells, and some of you may remember the name, their child ultimately died, and they were then prosecuted criminally. So anyway, another, again, tradition that seems to be recognized, and again, they're very powerful, in terms of economics as well. A little bit different from the Amish, who are more simple and so forth, but anybody been in downtown Boston, see the huge complex there, it's gorgeous. All right, let's look at Troxel v. Randall, our other substantive process case. So again, the state is the petitioner before the Supreme Court, and the Troxels, the grandparents, are the appellees. So, Patricia? How far over are the state? Did you also? Okay.
The state does not feel that,
Okay, just start at the beginning.
okay, the grandparents,
Give the
grandparents
procedural facts.
of Isabel and Natalie sued the mother for visitation rights under a Washington statute that allows any individual to sue for visitation rights. But the state looks at the...
So when you say sue the mother?
Sue the mother for visitation rights?
I would just change that language.
Sue the grandmother, sorry.
Well, again, I would
For more?
change that language. Want to help her? Tim?
Just for more. They had visitation rights. Weren't they just suing to get more visitation?
Does anybody see the word sue in the...
Yeah, the petition.
Petition the court.
Okay. Okay, so they petition the court. It's their petition for what?
Visitation.
Visitation.
Rights.
Okay. Under the Washington statute that you just mentioned. So the lower court is the Washington Superior Court. So what does that court do in the context of the litigation regarding visitation? What visitation do they get? Ask for? What visitation do they get?
It's only what is, the grandparents aren't allowed any.
Really?
No, that's not.
1 week per month,
Oh,
1 week during the summer.
They used
John?
That it unconstitutionally interferes with...
Wait, you're getting to I just want the facts, the
Okay.
procedural facts. So you started with the petition under the Washington statute that any party, any person, whatever, a non-parental person can ask for visitation, and we'll get to the standard of that afterwards. They file in the Washington Superior Court, and then what? Jeremiah?
The Superior Court entered a visitation decree ordering 1 weekend per month, 1 week during the summer, 4 hours on each of the grandparents' birthdays.
And what did the mother want?
The mother wanted 1 short visit per month.
Were they getting visitation before that?
Yeah.
Yes.
Yes. Okay, all right. Anything else about what the Superior Court does that we should know? Okay, so who appeals from the Superior Court's order?
Mother.
Mother does, okay, to the
Washington Court of Appeals.
Court of Appeals.
the Court of Appeals. Ash, and what does the Court of Appeals do?
They reverse that decision?
Yes.
Do they reverse the Court of Appeals?
Yes.
Yes.
You're thinking of the Washington Supreme Court?
No, the Court of Appeals reversed the lower court's decision, dismissed the petition.
Yep.
Oh, that's right, okay, but before that, didn't the lower court judge just sort of orally say stuff? And the
Well, he
appeals
wanted-
court said, you know, let's just send it back
Well, the appeals court
and
said
give us
that-
the reasons why in writing, give us your
appeals
factual
court said that
findings.
the grandparents lack standing, so the whole thing was dismissed. That's why they dismissed it.
Okay, but I guess what I was trying to get to was the reasons why ultimately the Superior Court, the trial court, puts in writing, right, the factual findings. Before the Court of Appeals ends up reversing, goes up to the Court of Appeals, the Court of Appeals sends it back down and said, you know what, you didn't put this stuff in writing.
Oh, they
And that becomes clear later on when we get to the care and protection
Oh.
cases, where judges have to do findings of fact and conclusions of law. Ash?
I said, don't they order more visitation to Granville?
I guess what I'm looking for, and it's somewhere in the opinion, the language that ultimately the trial judge puts for his reasons why he decided on that expanded visitation. Here, I'll read it to you if I can find it. The Troxels, quote, are part of a large central loving family. Remember that? All located in this area. The Troxels, can provide opportunities for the children in the area of cousins and music. The children would be benefited from spending quality time with the Troxels. And then the judge, again, says, meaning him, I look back on some personal experiences. We always spent, as kids, a week with one set of grandparents and another set of grandparents, and it happened to work out in our family that it turned out to be an enjoyable experience. So anyway, I just wanted to get to that part. Again, first, the decision was just an oral decision. This is what the visitation is going to be. She appeals. Court sets it back down and says, you know what, we want specifics. Then you're right, it goes back up to the Court of Appeals.
So that's a complete biased statement when the judge puts his own personal
Oh, yeah.
experience in it.
Yeah, and we'll get to that with the
Yep.
Supreme Court's
Yeah.
rationale. So what does then the highest court in Washington do?
They reversed the decision, holding that the non-parents lacked standing to petition under the statute.
Right, and it basically affirms, as you guys said, the middle court, the Court of Appeals.
Correct.
And then the U.S. Supreme Court affirms as well. So the U.S. Supreme Court affirms on what particular rationale? Lester?
That it's a presumption that parents act in the best interest of their child, and that the right of the parents is a fundamental cornerstone of liberty in decision-making about who has contact with their children.
So the court recognized it as it did in Meyer and Pierce, and you see the court
Parents' rights.
quoting from Meyer and Pierce. Getting back to the statute I mentioned before, what was the standard under the statute that the Supreme Court didn't like? What was wrong with the statute? In addition to, as Lester said, unreasonably interfering with the parental right here.
Wrong.
Judy?
It was very broad, and it also said that it placed the best interest determination
Mhm.
solely in the hands of the judge. So whatever he feels, then he can just do, which is not fair, because then infringes on the parent's fundamental right, as we spoke about, to rear their child in the best interest of their child.
So this is, again, important to remember for your cases later on. As Lester mentioned, there's a presumption that parents act in the best interest of their children. That presumption obviously can be overcome when children's, health, safety, and welfare are at stake.
They
But
did
the
note,
go ahead, Al.
they did note that even a fit parent is capable of treating their child like a mere possession. So you have to be careful on the other side too.
That's correct. That's correct. I've always also had trouble, I guess, with the distinction between what the court talks about early on, the liberty interests of parents that are not specifically enumerated in the Bill of Rights, right? And then in Troxville, and I don't remember if they used the word fundamental in Yoder, you start to see the court talking about the fundamental rights of parents. And I always thought of something that's fundamental that's in the Bill of Rights, such as the First Amendment. And so when it's a fundamental right, like Sarah Prince, the test or the standard is strict scrutiny, right? That the state has to show a compelling state interest for the intervention into parental life. You remember the language in Pierce was reasonable, rational, in terms of the rational relationship test, because the parental right was not specifically enumerated in the Bill of Rights, right? It's just the court construed that life, liberty, and property, that liberty that parents had, under that sort of general umbrella, a liberty right to rear their children the way that they please. But now you see the Supreme Court in Troxel using the word fundamental in relation to the same sort of parental right. The mom in Troxel was not, arguing any freedom of religion issue, just that she felt it was best for her kids to have the grandparents visit, just once a month. So, I don't know, keep that in mind. The court doesn't ultimately, I think it's White who concurs and says that the court didn't come up with a test in Troxel. White says the test should be strict scrutiny, but it's not. Again, it's not the law. It's a concurring opinion.
It's just that you're correct. They didn't come up with a test,
right?
But their language refers to a special weight,
right,
to parental decision making that it must be overcome to deny that, to deny them their
correct.
rights. So.
Yeah. Keep that in mind, because I'm, after many years, still confused. So I can imagine your confusion when you have common law. And I know a lot of you have had common law. Have you studied some of these cases in common law? Yes?
Yeah.
Troxville?
All
of them? Good. Who hasn't? You, Joe?
I don't study.
Okay, if you haven't.
Hopefully
when you get to common law, this might, be a little bit of a help.
We did some of these cases in family law too.
In family law as well, yeah. There's obviously an overlap, and much of family and juvenile law is nothing more than rights of children, families, the state. That's what it is, constitutional law. And I'm not a constitutional law scholar. I'm a juvenile law scholar, but I'm not a constitutional law scholar. So that's Troxel v. Granville. You guys ready for golf? Now we do a complete shift, because up until now, all this was substantive due process rights of the family, and whether the state should interfere and in what context the state should interfere. But now we're talking about procedural due process rights of the child. And I think I mentioned first class, Galt has been talked about and is the case still the case, the wellspring for children's rights. Come back to it again later in the semester when we do the delinquencies as well. So I want to do this first. Did you all get my email?
Yesterday?
Yes. I just want to make sure we're all set with our roles on Tuesday, should we run out of time today. So, we're going to do 3 little mini hearings. The first hearing, I don't need all of you for, but the second and third hearing, all of you obviously will have roles because I think there's 11 slots, I think. First hearing is the hearing in judges' chambers, in Judge McGee's chambers that would have been heard in the actual Supreme Court case of Galt. So I need somebody to play and really get into the roles here. I need somebody to play Jerry Galt, Mrs. Galt, the older brother, the 2 officers. I'll be the judge. You want to be the judge, Lester?
Yes.
All right, you can be the judge for that one. Okay. All right. And
This is for Tuesday, right?
yes. What's today? Tuesday. It's
Today's
for
not.
Thursday. It's for Thursday. Again, first hearing, Jerry Galt. Volunteers, Richard. Mrs. Galt. And you don't have to be male or female. Female in here could be the anyway, Mrs. Galt, Jadita.
Maybe the 70-year-old woman?
Later on?
Sure.
Okay, we'll get to that. Jerry's older brother, I need, because he comes into McGee's chambers. John, Officer Flagg. Joe, Officer Henderson. Officer Henderson. Tim. I'll be the clerk, since Lester has served me. All right, second and third hearings, and we'll keep the same roles. So wait a minute, 1, 2, 3. Jerry Galt.
I'll do whatever.
I was gonna say, Richard, do you want to continue to be Jerry Galt?
Sure.
Okay.
Plug me wherever you need somebody.
Who just said that, Jeremiah?
Whatever you want. Whatever. If you have a hole, plug me there.
District Attorney.
Okay.
Mrs. Galt?
Are you gonna keep the ones from the top or no?
If you want, some of those on the top can stay the same if you want. It's up to you guys. We can switch around.
I'll be a court officer.
Patricia, what do you want?
I don't care. Attorney for Jerry?
Okay. And you know what I'm gonna do? I want 2 attorneys for Jerry, so somebody else can also be co-counsel with you. John, since you're sitting right there. Okay. Back to, who wants to be Mrs. Gold?
I guess I'll be Mrs. Gold again.
Oh, Jadita?
Yeah.
Nadesh, what do you want? Do you want the officers? Black, Henderson, probation officer.
Is it the second and third year?
Yeah. What role do you want? I have Mr. Galt, Officer Flagg, Officer Henderson, probation officer.
Probation officer.
Okay.
Mrs. Cook?
Nadesh. Who's Mrs. Cook? Ash?
Yep.
That's right, you said that before. Okay. Joe? You want to be one of the officers, Flagg or Henderson?
Stick with Flag, I guess.
Flagg, okay. Lester, you can continue to be the judge if you want.
No.
No? Okay.
I'll do the first, the
Okay.
lower court.
Okay. So why don't I give you the judge's clerk?
Okay. That's in the second and third hearing?
Yes.
Can I switch and be the judge then?
Well,
If it's not too much to ask.
because I wanted to be the judge.
Okay, that's fine. I'll stick to Mrs. Goff, that's fine.
Because you're gonna need me for the third, because we're actually gonna do it cross and direct, and
Okay.
I'll be asking people to object to certain testimony and so forth, so you may need me. So, Tim, did I give you anything?
Not on the second one, I don't think.
Okay, so you were, why don't you be Officer Henderson again? And then Mr. Galt, Cassandra,
Yes.
you're Mr. Galt,
Mr. Goff.
and you're just gonna be outraged that your son is in this predicament. All right, let me repeat, and did anybody print it out?
The case itself?
No, the role-playing exercise.
Oh, yeah.
All right, if you did just, let's write the names, so you all know, okay?
Okay.
So first hearing, Jerry Galt Richard, Mrs. Galt Jadida, Jerry's older brother's John, Officer Flagg Joe, Officer Henderson Tim, Judge McGee Lester, and I'll be the clerk, all right? And then second and third hearings, Jerry Galt Richard, Mrs. Galt Jadida, Mr. Galt Cassandra, Officer Flagg Joe, Officer Henderson Tim, I'm the judge, and then two attorneys for Jerry, Patricia and John, District Attorney Jeremiah, Probation Officer Nadej, Judge's Clerk Lester, Mrs. Cook is Ash, okay? So the second and third hearings are after the Supreme Court decision. First being just the arraignment, the preliminary hearing where he's informed of his rights. The second being the hearing that will actually use the information. And Ash, you should be familiar with
I read it.
your
Yeah.
role. What
The
Mrs. Cook would
additional
test-
facts.
What's that?
The additional facts. you read it.
Exactly, yeah. Any questions? Okay. So, let's just run through it so you understand the case and the rights the Supreme Court guaranteed to juveniles in Galt. Anybody want to just briefly give me Jerry's procedural history? How about somebody that represents the child, either Lester, Richard, or Joe? How did this case start?
June 8, 1964, Jerry Galt gets picked up for a harassing complaint. At the time of his basic arrest, he was already on.
Okay, hold on. When he got picked up, where was he?
He got picked up by the sheriff of Gillett County.
Where was he? Where were his parents when he got
His
picked up?
parents were at work.
Okay.
They were not notified of his
Mhm.
subsequent detention.
Mhm.
At the time, he was already on probation for another matter.
Let me ask you this way. Was he the only one that was picked up?
No, two boys.
Okay.
Two boys that were picked up for basically making harassing phone calls.
Okay, go ahead.
Jerry Galt at the time had been on
So where was Jerry taken when he was picked up?
Children's Detention Center,
Okay,
which was run by the chief probation officer of the county.
okay.
At the time, he had been on probation because he had been with the boy who had stolen a woman's wallet.
Okay, so he's
Previous.
previously on probation. Okay.
They were both at work, the parents were never notified, and there were no steps made to actually notify them.
So how do parents find out where he is?
Mother showed up from work at about 6 o'clock. Where's my child? She sent his older,
I'm sorry, go ahead.
she sent his older brother out to look for him, and he found out through others that Jerry had been picked up
Who were the
by the
others?
police.
How did you find out? Where does he go? You said it was picked up with somebody.
The trailer home of the boy who was with the Lewis family.
Exactly.
And they had
Okay.
known that he had been picked up.
Okay.
And that's how the information got back to Mom. At that time, they went to the detention house, and the probation officer basically said, yeah, your son's here, there's gonna be a hearing in the morning.
Okay. Is this Flagg that you're talking about, or Henderson?
Deputy Probation Officer Flack,
Okay, all right.
who
And he
notified
said-
the parents that Jerry was
Yeah.
there, why he was there, that there was gonna be a juvenile court hearing at 3 o'clock the following day on
And
June 9th.
basically says, come see him, you can come see him in the morning.
Yes.
Okay, and then?
The officer filed a petition with the court the next day. It was not served on the Galts, and none of them saw the petition until August 17th, actually.
What's going on the next day? And who's there and where are they? Flagg had said, come to court the next day, you'll get to see your kid,
Yeah.
right?
It was basically a hearing. Not much information was given to them. It asked for the care and custody.
I'm
Flag.
sorry, who was present at this hearing?
Mother, older brother, probation officers Flag and Henderson, and the juvenile judge in chambers.
Okay.
Gerald's father was not there because he was at
So the hearing was in a room, not a courtroom?
Yes, in the
Okay.
judge's chambers.
Okay,
And also the complainant, Ms. Cook, was not there as well.
okay.
One of the big issues was no one was sworn at the hearing. There were no records made of the hearing. Nothing of
So
record.
you mentioned August, something happens later on regarding that case. Wait, does he go home that day? I'm sorry. On that day, does he go home? No. When does he go home, Jeremiah?
Eventually.
It was days later.
Days
I
later.
believe it was June 15th.
Okay, all right. Before the August hearing, he does go home, okay? And then they all go to court for the final hearing, which is in August, as you said, right? And what goes on that day?
That was the Hague hearing on August 17th.
The Hague hearing? What about what does the juvenile court judge find? Oh, maybe they did call it a Hague hearing, I'm sorry, go
Habeas
ahead.
corpus
Go
hearing
ahead.
on August
Yeah,
16th.
okay.
Where the judge vigorously cross-examined Galt and basically found the boy delinquent.
Okay, and? So where does Jerry physically go from there?
I forget what kind of school they name it.
Right.
They basically commit him to the juvenile detention center.
Okay. So how does the case then get to the Supreme Court?
I'm looking for the exact, but I can't find
Anybody want to help him? How does the case get to the Supreme Court?
Constitutional validity?
I'm sorry?
Constitutional validity of the proceedings?
No, how does Jerry appeal? How does Jerry get to, how does the Supreme Court get to decide this case? He's committed, right? That's the last I heard. After he's committed, what happens?
Sorry, I have it.
Huh?
No appeal is permitted by Arizona law in juvenile cases. August 3rd, 64, a petition was filed with Supreme Court of Arizona and referred to this. Oh, that's correct. Suspicious.
Notice it's called in re, right? So not state, Miami, Nebraska, state versus, it's in re application of, so what does Jerry Galt's lawyers apply for?
Review.
Well, the Supreme Court ultimately reviews it, but he applies for what?
A writ.
What's that?
A writ.
A writ of cert, right? Okay. That's all I was trying to get to. So, I mentioned before, we're talking about procedural due process, so the test is a little bit different. And I like to think of it in sort of two, it's still life, liberty, property we're talking about, but you ask yourself two questions. Is process due? Process. And once you get the answer to that, what process? Is due. So what is the nature of Jerry facing a juvenile adjudicatory proceeding to determine he's a delinquent child? What is the nature of his rights, his due process rights? One word, life, liberty, or property. What has he got?
Notice of the charges?
Liberty?
You're talking about rights. Liberty, his liberty right is at stake because Richard just told us that he ultimately got committed. No going to school every day. No skipping school and doing prank calls. No doing chores for mom and dad. No going shopping. Committed till, and I forget, it was age 18 or 21.
21.
Yeah. Okay?
21.
So his liberty is at stake. And again, because it's in the nature of now a fundamental right, the process that's due is pretty hefty. All right? Later on, when we get to the school, the students' rights, the right to education doesn't, rise sort of to that level. So the minimal due process that, say, a student has in the nature of a, controversy, a legal action, is just the, notice and opportunity to be heard. But again, because kids like Jerry would get jailed as a result of a conviction like this, now we can talk about the rights that you started to enumerate, Ash. So out of Galt, we're talking about 4 very important rights that children are afforded from this case forward when they are in the middle of a adjudicatory proceeding where their liberty is at stake. Richard?
Notice of charges.
Okay, so notice. Yeah.
Right to counsel.
Counsel.
Right to confrontation of accusers.
So confrontation and cross-examination. And
Right to appellate review.
nope. Somebody help him. What's the other right?
Against self-incrimination.
Yes. Why is it not right to appellate review, even though he argued that? He wanted that.
It can be denied.
The Supreme Court did not address that question. Okay. These are the only 4 rights that come out of Galt. Not again that specific states might give the right to appellate review, which we do in Massachusetts anyway. But those are the 4 procedural due process rights that any child facing, and I keep saying adjudicatory. This was the case that narrowed, I guess, even though it was in the context of the Wellspring for Children's Right, now children get counsel, okay, but only in an adjudicatory delinquency proceeding. So this case, at least at the time, that was its narrow holding. It couldn't stand, for example, it couldn't stand for the proposition that a child who's subjected to neglect and abuse, where the parents are brought before the court, that under Galt, specifically, the child doesn't have a right to counsel. You will see later on, however, that Massachusetts and most states do afford children attorneys in the neglect and abuse cases. But again, Galt's right to counsel only applies to juveniles in adjudicatory proceedings. It's been extended, obviously, to dispositional proceedings as well. When we had transfer proceedings, we don't have those anymore. We'll get to those later on. to children that even don't commit crimes. Massachusetts CHINS, which is called something else today, right to counsel as well. So that's why it's called the wellspring. The rights that are talked about in this case have been extended in other areas. The notice requirement, that's particularly important because a child is normally, and you guys talked about it here, the presumption that parents are fit and so forth. The child is normally within the parents' custody, right? Care and custody. So who gets notice under GALT?
Parents.
Parents and the child. Well, you know, the child normally resides with the parents, so and that's important again later on when we look specifically at the delinquency cases. Even though the child is the party, it's the Commonwealth prosecuting, you know, the child for having committed a crime, parents are involved in the process as well. So for example, if the child is going to waive counsel, the parents have to be involved in that decision, as an example. So the notice is for parents and for children. The counsel, another issue we'll talk about at much length as well is counsel for the child. What does that mean? What's the role of children's counsel? Children, by their nature, are not as mature as adults, etc. They may have different mental health needs and all of that. So what does that specifically mean? You know, counsel. Confrontation and cross-examination. Later on when we discuss and engage in the child sexual abuse, hypothetical / real case, we get into those issues as well in terms of child witnesses, in particular when the perpetrator is someone in the family, and you know, what does that involve? And then self-incrimination, again, the right of the child, you know, not to speak, and does the child understand all of these rights? So anyway, those are the 4 rights, procedural due process, that Jerry would have, that the judge may or may not, we should be applying, I guess, in the first hearing. The first hearing is only going to be the arraignment, very quick. You know, the child and the state appear before the judge. The state, you know, basically summarizes the substance of the charges. It's not a plea, although, you know, you're before the judge and the judge needs to know what would be happening with this case. So does it get continued for pretrial motions? Does it get continued for a plea, or and so forth? The judge also giving the child his basic rights, the right to speedy trial. Again, the notice is already happening because, you know, parents are there because they have been notified, and child is there with the parents. He may or may not have been arrested and held and all of that, but they've got their notice. Confrontation, cross-examination, self-incrimination only will come up within the context of our mini 3rd hearing. And the only witness will be Mrs. Cook. We don't have time for much more than that. So that's it. And so that we'll be ready to go on Thursday with that. All right, it'll be fun. All right, thank you.